All right, you are now live.
Welcome, everyone, to the Maryland Attorney General's COVID-19 Access to Justice Task Force Community Forum on Life and Health Planning. I am Danielle Crittenden. I am one of the co-chairs with Julie Bell of the Life and Health Planning Committee of the task force. And tonight we have a program that will address what documents are helpful, legal documents are helpful to have in a time of illness and to plan for your family at the time of death. But before we get to that, I have the honor and privilege of introducing Maryland Attorney General Brian Frosh, who would like to make a few comments. Mr. Attorney General.
Thanks a lot, Danielle. And thanks to everyone for joining us. I think we have a very informative program lined up for you. We have some experts, Paul Ballard from our office, Timothy Chance from the Maryland Volunteer Lawyers Services, and Karen Pope Onwukwe from her own office. She's a lawyer in private practice, but specializes in exactly what we're talking about tonight, health decisions. And as you know, or I expect you wouldn't be here, everyone has the right to make decisions regarding their health care and their financial assets and how they should be handled if you or a loved one becomes incapacitated. It's important that you make these decisions while you're able to do so. Otherwise, they'll be made for you and they may not reflect your wishes. The speakers this evening will talk about what documents you need to prepare and how those documents will communicate your wishes if you're unable to. Documents like for medical care that spell out exactly what care you wish to receive or don't wish to receive, as well as what forms you may need to assign to someone, what forms you may need to have someone handle your financial affairs for you and how they should handle them. Healthcare, financial planning doesn't just protect you, it protects your loved ones, especially if you're able to be specific about your wishes and you want to ensure that all the legal paperwork is complete prior to any life-altering event. Now, talking about this stuff, especially end-of-life care, is really difficult. They're hard conversations, but having those difficult conversations can save you and your loved ones further grief and pain during even more difficult times. So I want to thank all of the members of the COVID-19 Access to Justice Task Force. I want to thank our partners, the Maryland Bar Association and their Access to Justice Commission, for the amazing amount of time that they have dedicated to these issues. And I want to remind you that this program will be videoed and it will be up on our website, marylandattorneygeneral.gov. So if you miss something, you can watch it again. And it'll be there along with the programs we've already done related to this crisis that we're in. They relate to evictions and housing, consumer debt, surviving abuse, neglect, and exploitation. So if you have any information that you need, go to our website, marylandattorneygeneral.gov. You'll find presentations like the one you're about to hear on those other subjects as well. So thanks very much for joining us. And thanks to all of our panelists. Danielle, back to you.
Thank you very much. And I would like to mention that also on the Attorney General's website, we will be posting a handbook. It is in its final stages of being reviewed and will soon appear on the website, along with a resource directory that you will find helpful. The format for tonight is that we will reserve 15 minutes at the end of tonight's program around 5:45 for questions that you can put in the chat. And I can then present those questions to our panel. But we have a lot of material to cover, and we do have an excellent panel. Attorney General Frosch did, introduce our speakers, but I would like to tell you a little bit more about them and what they intend to cover. So first, speaking this evening will be Assistant Attorney General Paul Ballard, who is counsel for Health Decisions Policy. He was actually on the legislative team that helped write the law and regulations regarding the Maryland Orders for Life-Sustaining Treatment Form, and he educates care providers and consumers regarding laws related to healthcare decisions, and advises state regulatory agencies regarding these issues. And so Paul will be covering the topics concerning advanced medical directives and the what we call the MOLST form. That is the form, that's the acronym for Medical Order Life-Sustaining Treatment. So you will be hearing from Paul on those topics, followed by attorney Karen Pope-Anukwe, who is a well-known elder law and disability rights attorney who has a practice in the Prince George's County area. Karen has served in various roles for various state bar organizations. She's currently serving as an appointee to the American Bar Association's Commission on Law and Aging. Her practice involves elder law planning, wealth transfer planning, preparing the kinds of documents that you're going to hear about tonight. And specifically, Karen's going to cover the topic of financial powers of attorney. She's going to mention briefly some things about guardianship, and she's going to talk about the important topic of asset titling and how property is owned and titled. And then Karen will be followed by attorney Timothy Chance. And Timothy is a tangled title attorney with the Maryland Volunteer Lawyer Service Organization. And he helps individuals who have a legal interest in their homes, but they're not the legal owner. And he offers representation in estate administration and deed transfer cases. And he's also supported volunteer attorneys accepting these kinds of cases and helps them to develop substantive resources. Prior to joining the Maryland Volunteer Lawyer Services, he served as a staff attorney at the Baltimore City District Court Self-Help Center. So he's the perfect person who will be talking to you about deed ownership, house ownership, but he's also going to cover the topic of wills and non-probate transfers. So without further ado, I'm going to turn this over to Paul Ballard. Thank you, Paul. You need to unmute yourself, Paul.
Sorry about that. Now I'm unmuted. I can talk. Still haven't quite gotten used to this. I'm Paul Ballard. I'm an Assistant Attorney General, and I want to thank the Attorney General for his introductory remarks. I thought they were very on point. I'm going to be talking to you today about advanced medical directives and the Maryland Medical Orders for Life-Sustaining Treatment form. And these are legal documents that are very helpful in carrying out what you want. And they're most effective when you actually talk to your family members. So it's really important to key them in on what's important to you, what's of value to you. What quality of life is really important to you? Are you okay with being kept alive on machines? Or what does that concern you? And would you like to have restrictions? So the advanced medical directives allow you to take control over what you want. And by telling your family what you want, it allows them to know, and that really helps them make some really difficult decisions on your behalf. Okay, so are you going to forward this, or do I control? Okay. So what is an advanced medical directive? So an advanced medical directive is a legal document that speaks for you when you can no longer speak for yourself. An advanced medical directive can contain one of two things. It can be what we call a healthcare power of attorney. It enables you to choose someone you trust to make healthcare decisions for you, which is very important because otherwise the law will try to find someone based on their relationship to you as a family member, but it may or may not be the person you'd like to make decisions for you. And the healthcare power of attorney can let you choose someone you really trust to make those decisions, and it can give them a great deal of power to do what you would do if you could do it yourself. Also, an advanced medical directive could contain what we call a living will. And a living will tells people what treatments you would accept should you ever be in a certain medical condition. You're not in that condition now, but you're concerned that, maybe one day I'll be terminally ill and they'll want to keep me on machines, and I don't really want to be kept on machines. I want to have a peaceful death and pass naturally. You can say that in your living will, and that gives more enforcement to your wishes. It gives a documentation about your wishes, and it also is a way to additionally communicate to your family your wishes. So it's very useful. Next slide. So an advanced directive helps to ensure that the healthcare you receive is consistent with your wishes regarding your quality of life, what the quality of life you desire. So that's really what created the law in the first place. People were concerned about their quality of life. Were the treatments they're getting in accordance with their values and their beliefs and what they would want? So that's why it's really helpful to carry out what you want. So by making your wishes clear to your loved ones in an advanced directive, you can help to ease their very difficult task of making healthcare decisions for you. And we all know it's very hard to know when to let a loved one go and when maybe you should have more treatments for them. So these are very hard decisions. And so the more guidance you can give to your loved ones, the better they're going to feel about those decisions. And when they know about what healthcare you would want, it really can help them to alleviate their guilt, because it's really hard to know whether they think, oh, am I letting my loved ones suffer too much, or am I not fighting enough for them? And these are very hard decisions. So this can also, by having the discussion with them, and that's really the most critical part, is having a discussion, but also having the documents can help avoid having real bitter disputes among family members. And these disputes can last for a long time after you die. And so you don't want to leave that legacy for your family members. When I had family members who maybe had wishes that I didn't want, at least I knew about them, and that made it so much easier, because otherwise it would have been hard for me to say, oh, yes, that's what you should do. But because I knew what they wanted, it made my task so much easier. And it made everyone in the family was aware of that, their feelings about what they need to do much easier. So if you just think about basically what you want, what treatments you're willing to accept, even if it's just a basic values conversation with your family members, I don't want to be kept alive, by way of a feeding tube if there's no hope for recovery, things like that, or on a ventilator if there's no hope for recovery. If that's what's important to you, just make some basic statements to them so they know. The next slide, please. Now, the Maryland Attorney General has an advanced medical directive form that is free, and you can download it at that site. You can also email your request for a printed copy to adforms@oag.state.md.us or call that number, 410-576-7000, and we'll be happy to mail you a copy. Other organizations also offer advanced medical directives that are legally valid in Maryland. There are many places you can get them. Next slide. Okay, so how can I make sure my advanced medical directive is valid? Okay, now they made sure to make advanced directives a very relatively easy thing to do in Maryland. They wanted to encourage people to do them. So there really isn't there aren't really a lot of requirements. It has to be about healthcare. You have to sign and date the advanced medical directive in front of 2 witnesses. Make sure that none of your witnesses are people you appoint as a healthcare agent in your advanced directive. And only one of your witnesses can be someone who will financially benefit from your death. So I generally tell people, just don't have family members witness your signing the advance directive. You do not need a notary, but a notary could be one of your witnesses. You do not need an attorney, but if you have legal questions, they can be helpful with those. So all of these laws in Maryland are designed to make it very easy for you to prepare an advance directive. Also, Maryland recognizes advance directives completed in other states. So if you completed one in Virginia and you did it so in accordance with Virginia laws, it's accepted in Maryland by law. And that would be true by any state. Next slide, please. You also may complete advanced medical directives without witnesses if you do it electronically. Maryland law was changed recently in the last few years to allow this to happen. What you will need to do is go to a website that provides electronic advance directives. Because no witnesses are involved, they'll need some of your personal information. I recommend that you go to mydirectives.com because they've been approved by the Maryland Healthcare Commission as meeting the standards required in law for electronic advance directives. Now, it may be that other electronic advance directives also meet standards that Maryland has set forth, but we know that MyDirectives does. And so you can go to their website that's been circled. And one additional advantage of an electronic advanced medical directives is that it can be stored and accessed online. So that's really a critical point. A lot of times the problem with advanced directive is making sure you bring it with you in that crisis when you go to the hospital, that you have a copy. With a paper advanced directive, someone's got to carry it to them. If you do it electronically, sometimes that makes it more, it facilitates the ability to get access to it because the hospital can go to the website and bring up your directive. And there are efforts now to, and an ability now for healthcare providers to access advanced directives over the state designated electronic health database, which is called CRISP. And so that's the way you can store them electronically, which is very helpful too. Next slide, please. Now you want to keep your advanced medical directive where it can be found easily. It's very important that people find it. You don't want to go to all the trouble of creating an advanced directive and no one knows where it is. So you want to give a copy of your advanced medical directive to your healthcare agent. And of course, you should talk to them about it and they should know what's in your advanced medical directive. Actually, I think anybody who shows up to the hospital to visit you should probably know at least generally what's in your directive, what's important to you, so that they don't fight with each other about what you want. Giving it a copy to your doctor is very helpful. I recommend people complete a wallet card so they can tell people, because they'll go through your wallet if there's a crisis, looking for information. And if there's a wallet card that says, I have an advanced medical directive, this person holds a copy of it, this is their contact information, this is my healthcare agent, this is how you can get a hold of them. That's very helpful for the healthcare providers. And they really need this. Now, in this time of COVID, they need to know information as quickly as possible. So the more you can have that in place, the better they're going to be able to meet your needs as a treatment provider. So the Maryland Attorney General's Office has a wallet card available. So you can go to that site that I've put the link here, and you can get the wallet card there too. But other people will have wallet cards too. You can find them online pretty easily. Next slide, please. So I'm going to talk now about the Medical Orders for Life-Sustaining Treatment Options form, which is another legal document, which is a little different from an advanced medical directive. You can think of the MOLS form kind of like you would think of a prescription. It's a doctor's order. It's a doctor's order about basically what's going on with you now. It's you have a current condition that's making it difficult, let's say, for you to eat, and you're concerned about whether you want to be on a feeding tube. So you may have your physician or nurse practitioner, physician assistant, sign a MOLS form on your behalf, which will have a medical order saying, do not give artificial nutrition hydration. So it's about something that's happening with you now. It's about your current medical condition. So the MOLS form contains medical orders about treatments that keep you alive, such as CPR in a crisis, artificial ventilators, feeding tubes, etc. So the MOLST form has medical orders to carry out your treatment wishes regarding your current medical condition. Next slide, please. Now, what is the difference between a living will that you would have in an advanced medical directive where you said, these are the things I want for treatments or I don't want for treatments should something ever happen to me, and the medical orders and a MOLST form? The difference is this: a living will is something that you prepare by yourself or with a lawyer about something far off in the future, some hypothetical future medical condition. You know, it's important for every one of us to have an advanced directive, even if we're young. You know, when I've talked to high school students, say, well, you know, you could be in a car accident tomorrow and you could fall into a coma, and we'd want to know what you would want for treatments. And that's really the purpose of a living will, is something in the future. It's a hypothetical, but you're concerned that there may be a day, someday where you're in there's this condition and you're concerned about being kept alive. You're concerned people won't give you treatments, because it can also go the other way, that you'll get treatments and make sure that you get them. So that's about future hypothetical conditions. The MOLST form is about what's happening with you now. What is your current medical condition? Because what's happening is the physician or the nurse practitioner or physician assistant is creating medical orders that can be acted upon right now to carry out your wishes. And the healthcare system responds to medical orders. So that's what they honor. So the idea of the MOLST form is that these medical orders travel with you wherever they go, and people honor them wherever you go. So one very important thing to remember from this session about the MOLST form is that if you do not want CPR, you must have a do not resuscitate order. Okay? And that do not resuscitate order, the DNR order, is in a MOLST form. Okay, so that's very important to understand. Sometimes people think, well, if I do an advanced directive, I'm done. They're not going to give me CPR because I said I didn't want that kind of thing, should that ever happen. If you call 911, the EMS people are going to look for a MOLST form. If they don't see one with a DNR order, they're going to begin CPR. Now, there might be all this discussion about, well, here's the advanced directive, and oh, you know, and someone might be reviewing that while you're getting CPR, but because they have to do CPR right away for it to work, they're going to start it right away. So that's why it's very important, if you don't want CPR, to have a DNR order on the MOLST form. Next slide, please. So just like an advanced medical directive, it's very important that a MOLST form should be kept where you can easily have it found when you call 911. You want them to easily be able to find it. Now, the EMS people have a protocol that they follow. And when they go to someone's home, they're going to look certain places for that MOLST form. And so if it contains a DNR order form, it's really important for you to keep them in those places, especially if you're alone and something happens to you. They're going to look for these places. They're trained to do this. They're going to look on your refrigerator door, by your bedside, or behind your bedroom door, because these are the places where they look, and they've been trained to look for the MOLST form in those places. You may also want to get a medic alert bracelet or another bracelet that you can get through MIMS, the agency that regulates ambulance providers. They also have a plastic bracelet that you can put a MOLST form insert into it, but the medic alert bracelet is a little more permanent. And you can call them, they'll need a copy of the MOLST form. And that way you'll have a bracelet or a necklace with your DNR order there, no matter where you are. You know, if you collapse in a parking lot somewhere and the EMS people come, they can see your bracelet and honor your wishes. Next slide, please. So if you want further information about advanced medical directives, we have a lot of information on our Attorney General's website. We have advanced medical directives, we have basic information, we have in-depth legal advice and opinions. It's all there. Also, further information about the MOLST form is available at marylandmolst.org. And that has patient guides and professional guides. It has information sheets. It has the MOLST form. And if you have questions, one thing that is very nice, and I really am proud to work for the Attorney General, and for many years, consistently, consecutive attorneys general have made it very important to them. It's been very important to them to educate the public about advanced medical directives. So your general questions about advanced medical directives in most forms will be answered. Now, I'm usually the one who answers it. I'm not giving you legal advice. That you need to seek through an attorney, but I can give general information and your general questions can be answered. The best way to go to do that is to go to the Maryland MOLST website. They have an email, maryland.most@maryland.gov. I'm the first one usually to see those questions, and I can, if they're clinically oriented, I can consult with clinicians before I respond back to you. Is that, yeah, that's the end of the presentation. Thank you. I'm going to shift it over to Karen Pope Onwukwe. We'll now be discussing managing financial decisions.
Thank you, Paul. And thank you all for tuning in. I'm going to talk about managing your financial decisions. And what the legal document that you need to use to manage your financial decisions is a financial power of attorney. Many people don't realize that their spouse or relative or friend, they don't have legal authority to manage your affairs if you're not able to do so. If you are over the age of 18, legally you're an adult. And if you lose the ability to handle your affairs, you do not have, even your husband does not have the right to handle your affairs. The preferred solution that we're talking about tonight is a financial power of attorney. The less attractive solution, and I'll talk about that somewhat, is guardianship. So we'll go to the next slide, please. So a financial power of attorney, many times people are confused and they'll call me and they'll say, I need to get a power of attorney for my mom to manage her affairs. Well, I tell them, I need to talk to your mother because your mother is the principal, the person who appoints an agent to have authority to make financial decisions. So that means that the mother would be the person signing the document, and the mother would appoint the daughter as the agent to give her authority to make financial decisions. Now, a power of attorney, one of the things that the principal, the mother, in this scenario, would have to understand is she does not relinquish her authority. Many times you can create a power of attorney and you can still sign your checks or do whatever it is you need to do financially, but you want to have that document in place in the event that you do not have the ability to do that. The authority can be broad or narrow, depending on what you want when you draft the document. And again, your agent is a fiduciary. A fiduciary is a person who has legal limits on what they can do with your money. They cannot use your money for their own benefit. They have to use your money for your benefit. An agent must be trustworthy. Sometimes I talk with clients and I'd say, you don't necessarily have to choose your oldest child just because it's your oldest child. You need to choose someone who is trustworthy, who has the ability to understand finances. And it doesn't have to be your child. It could be a friend. But your agent, the person that you appoint, has to be trustworthy. And also many times people say, well, can I have more than one agent? You may have more than one agent. You can have 2 agents. You can have 3. You can have the agent say, okay, Paul will be my agent. If Paul can't do it, then I'll have Danielle. If Danielle is not able to do it, then I'll have Tim. And so you would have 3 people that can consecutively handle your affairs if you're not able to. We'll go to the next slide, please. Now, the tricky thing sometimes is that the principal must have legal capacity to sign the document. And, you know, a lot of people talk about capacity, and they want to say that I get calls and they say, well, my mom doesn't have the capacity to do this or do that. There are ways that capacity can be determined, but traditionally, if a person knows the assets that they have and they can articulate that, and if they are know who they want to handle their affairs, they should be able to sign a power of attorney for finances. Your document must be specific enough to allow third parties to accept the document. We have in Maryland, we had adopted the Uniform Power of Attorney Act, and there is some specific language that should be in your document. And if that language is not in your document, banks may say, we're not going to accept that. So I tell people to be cautious, because there are a lot of websites you can go to nowadays and download documents. The document may not be specific to Maryland. You can go to the Attorney General's website and get information on the Maryland Power of Attorney and the specific language that we require. Now, a Power of Attorney document can go into effect immediately, or it can spring into effect at a later time. You may sign the document today and not use it, but next week you may have a stroke and you need to use the document. You don't have the document. We call all power of attorneys in Maryland are what we call durable, which means that even if you're hale and hearty today, if something happens to you, that power of attorney will still be in effect if you lose capacity. A principal has the right to revoke. If you have a power of attorney and you determine that the person that you've appointed to serve as your agent no longer has your trust, you have the right to revoke that document. That is, and you can have another document prepared, or you can tell the person, I no longer want you to be on my power of attorney. Let people know, banks or financial institutions, that you've revoked it. Especially if the person has used your power of attorney to work with your bank or financial institution. One thing that's important for people to know is that a power of attorney terminates when the principal dies. So if I created a power of attorney and I died tonight, Paul could not go, if he was my named agent, he could not go to the bank tomorrow and remove money from my account under the power of attorney, because the power is extinguished when I take my last breath. Next slide, please. Now, there are alternatives to managing financial decisions. Some alternatives to a power of attorney, you can create a trust. Now, there are two kinds of trust or areas. You can have a trust that you create while you're alive. That trust is a standalone trust. It's called a revocable living trust. And those trusts, typically what you do is you put all of your assets inside of the trust. And while you're alive, you are the trustee of the trust. And you go on, you do everything that you normally do. The only thing you do is you change the title, and they'll be talking about titling later on. But you are the trustee of the trust. The trust is for your benefit. Upon your death, a revocable living trust would become irrevocable. While you're alive, you can change the trust. The trust should come with what we call a pour-over will, so that if there's anything that you leave out of the trust, it will go into the trust. I would advise, if you're going to be using a trust that you meet with an attorney. There are irrevocable trusts that you can create. Usually those are created for tax purposes. And that is normally people have a great deal of wealth if they're using an irrevocable trust. And it's for tax planning. Now, again, with trust, I think you definitely need to talk with an attorney, meet with an attorney. Now, a lot of people come into the office and they have joint ownership. They put their son or their daughter on their bank account. They put their son or their daughter on their deed to their house. There can be some problems with joint ownership, but that is a way that you can manage it. That is not the first choice for me advising clients, and Tim will be talking more about ownership, joint ownership later. But that is a way that you can. That is an alternative to a power of attorney. If all else fails, you have to go to court to get a guardian of the property. Now, I tell you, a power of attorney may cost you about $200. If you're going to court, you're going to start at maybe like $3,000. It's more expensive to go to court. Under Maryland has excellent guardianship laws that try and protect the interest of the person who's going to be subject to the guardianship. And so what happens is that if you are going to court, you have to notify all of the interested persons. Sometimes it can become a court battle. I've gone to court and there are 5 attorneys because there are 5 kids and everybody's fighting about who should be the guardian for mom's assets. So it can be time consuming. And then it also requires court supervision because the court is actually the guardian, and the court will require whoever's appointed to be the guardian to file an annual report. I will caution you also, I always tell clients, the court may not appoint you as the guardian. Just because you apply to be the guardian, there are things you have to qualify to be the guardian. If there's fighting between the siblings, the court may appoint an attorney to be the guardian of the property. So you have to be very careful in reference to filing these petitions for guardianship of property. We'll go to the next slide, please. One of the other alternatives that we have and that we talk about that is available to people is something called a standby guardian. Many times, if you have a minor child, you may need to have someone to take care of your child if you're not able to do so. And we've found, so Maryland has put a form that you can fill out to designate someone to become the standby guardian for your child, for your minor child. And it's a designation and a consent form. So what happens is, in the event that you are not able to take care of your child, let's say you have some kind of mental breakdown or something of that nature, and the doctor says you need someone to take care of your child, this may be a document that can be used. If you have some kind of physical debilitation, let's say you have a heart attack and you're going to be indisposed for a period of time. And then another area where this becomes very important is a parent who is subject to an adverse immigration action. There are people that they may face deportation or arrest or all kinds of issues dealing with immigration. And in that instance, what we do is we ask that, well, you can ask someone to be the standby guardian for you. Now, what you have to do is you have to fill this form out beforehand, and the person who is going to be the standby guardian has to consent. They have to sign it. You also need to make sure that you have your child's birth certificate, because that's going to be a document that is necessary if you have the standby guardianship. The standby guardianship will only last 180 days. If you believe that within this 180-day period that you may need to continue the guardianship, you must petition the court to extend the guardianship beyond 180 days. If you have to petition the court, then you also have to give the court, let's say the person has had some kind of adverse immigration action. You need to have some kind of verification that has happened, something from an official verification. If the child, if you are sick, you need to have some official verification from your doctor, from your physician, that can be submitted to the court to verify that you actually are sick and that you're going to be sick for longer than 180 days. The same thing if you have a mental incapacitation. If you may need to get something from your psychiatrist, or if you're in a mental institution, some verification that you will need the guardianship for longer than 180 days. And then you may have to go through the guardianship court proceedings, which, as I mentioned before, can be pretty onerous. Most of the courts, they have to have a hearing. You have to be able to present that evidence to the court before they will allow the person who is under the guardianship to, before they will allow the guardianship to continue into a permanent guardianship. So those are the things that you need to think about in reference to property, and especially if you have minor children, so that we've learned with this pandemic that things can happen and they can happen quickly. So you need to have these documents completed before something happens. Get it? I think Nike has a saying, just do it. So you need to get these documents done and have them in place so that if you need them, they will be available to you. I think that I'm going to now hand it over to Tim.
And I'll just jump in real quick here and mention that we will cover the rest of the topics, and our questions will begin at the end of the presentation tonight. So even though this was originally planned to end at 7 o'clock tonight, we will still be taking questions at the end of the program. So thank you all for your patience.
Okay, thank you, Karen. All right, so thank you all for joining us this evening. So I'm going to talk about property titling. So property titling means figuring out who owns the property. So such as a bank account or your home, and what rights each owner has to that property in question. So next slide, please. So there are multiple forms of property ownership. One is just owning property solely. That's where you're the only named owner and there are no joint owners. Another option is owning the property together with your spouse, and that's where you have what is called tenants by the entirety. And then lastly, in this slide, we also have joint ownership. So there's two different types of joint ownership I want to talk about. We have joint tenants with the right of survivorship, but then there's also tenants in common. And I'll dive into those in more detail in future slides. Next slide, please. So going back to sole ownership. So if you are the only owner of any type of property, you usually are the only person with any type of legal rights to that property. For example, if you are the sole owner on a bank account, you're the only person that can withdraw funds from that bank account. If you're the only person named on your deed, you're the only person with the power to then sell that property. So if you become disabled, no one else has access to that property unless you have already given them a financial power of attorney, like we talked about earlier, or unless they petition a court to become guardian of the property, which is also touched upon. Upon your death, you can control who inherits the property. This can be done with beneficiary designations. We generally see this with life insurance and retirement accounts. And we'll dive into some other different types of beneficiary designations in future slides. But it can also be done through your last will and testament, if you have one. If you don't, then state law controls and decides which of your family members will inherit your property. Next slide, please. So when there are two spouses, you have tenants by the entirety. So what that means is the property belongs to the marriage and is not owned by either spouse separately. So in this state, in Maryland, that means that if one spouse has any debts, the creditor who is owed money generally may not take any property owned as tenants by the entirety. And with bank accounts, if one spouse becomes disabled, the other spouse can still access the bank account. For real estate, so for real property, if one spouse becomes disabled, the other spouse would then need a financial power of attorney or guardianship in order to sell, mortgage, or devise the property on behalf of the disabled spouse. And then lastly, if one spouse dies, the other spouse automatically inherits this type of property. Next slide, please. The other type of joint ownership is joint tenants with the right of survivorship. So this can be used for ownership with two or more people. So if you have bank accounts, if one owner becomes disabled, the other owner then will still have access to the property in the bank accounts. For real estate, all owners have the right to use and access the property, but if one owner becomes disabled, the property needs to be sold, or the property needs to be sold or mortgaged. Someone would then need a financial power of attorney or guardianship to do so on behalf of that disabled owner. And if one owner has debts, the creditor can then access the property to be repaid. And if one owner dies, the other owners automatically inherit the property. Next slide, please. The other type of joint ownership is known as tenants in common. So this can also be used for two or more people. It can be equal. It does not need to be. For example, you could have one owner with 80% and a different owner could have the other 20%. So with bank accounts, if one owner becomes disabled and the other owner becomes disabled and the property, if one owner becomes disabled and the other owners will still have access to the bank account. And if real property, all owners can use the property. And if one owner becomes disabled and the property needs to be sold, mortgaged, or devised, someone else would then need a financial power of attorney or guardianship to do so on behalf of the disabled owner. If one owner has debts, the creditor can access the property to be repaid for those debts. And then this form of ownership differs from joint tenants with the right of survivorship, because if one owner dies as a tenant in common, the dead owner may choose who then inherits his or her share of the property with the will. Okay, next slide, please. So generally, ownership can be complex. So the forms of ownership can be combined. For example, we have an example here. The ownership in a home might be divided equally as tenants in common, but with 50% owned by a married couple as tenants by the entirety, and then the other 50% owned solely by their daughter. The decision of how to title your property can significantly impact the taxes, your creditor's rights, your qualification for public benefits, and it also can change who can access or inherit your property. So I think it's very important that you consult with an attorney prior to making any changes to the titling of your property. Okay, next slide, please. Following up on that, I want to talk about wills and non-probate transfers. So just like we touched upon, there are multiple ways that you can own property, and there's multiple ways that your loved ones can receive your personal belongings or any property after you die. So like we just said, if you die, anything that you jointly own with another person can automatically belong to that surviving person. If you have property that has a designated beneficiary, that property will then automatically transfer to that beneficiary. And like I said, this is common with life insurance policies and retirement accounts. It can also be used for 401ks, TSPs, and certificates of deposit. And then lastly, a will can help make sure that when you die, any of your property, which is solely in your name and does not have a named beneficiary, will be distributed according to your wishes. Next slide, please. So a little bit more about wills. So what else can a will do? So although a will is typically known as a document that determines how property is distributed upon death, there are other important parts of wills. Perhaps most important of all, a will can be can be used to name a guardian to care for your minor children in the event of your death. A will is also a place where you can designate a personal representative who will be responsible for administering your estate through the court process. And a will is also permitted to waive the bond requirement for the individual serving as your personal representative. And this will allow your personal representative to manage the process without requiring them to be insured for the value of all the property of the estate. And in most cases, waiving the bond requirement is a way to minimize the expense associated with administering estates. So there are things that a will can't do also though. So a will cannot override joint ownership of property or any beneficiary agreements. And also it cannot take away from your spouse's right to inherit from you. Next slide, please. So what is required to have a valid will? So it's critical to make sure that your will meets all of the technical requirements of a legally valid will, including that it's properly signed by you and witnessed in order to ensure that your will is accepted by the court at the time of your death. A will in Maryland must have two witnesses, both of whom are over the age of 18. They both must have watched you sign your will. So a will does not need to be prepared by a lawyer to be effective, but a lawyer may be able to provide you with guidance on how to navigate complicated situations, such as planning for family members with disabilities or planning for blended families. So ultimately, I strongly encourage you to speak with an attorney to have them go over drafting your will for you. Next slide, please. So once you have your will drafted and executed, where should you keep it to ensure that that's kept safe and that your beneficiary or your heirs and your PR, your personal representative, can access it at the appropriate time? So it is extremely important that your original will be located after your death. So in other words, this is not a copy, the original will, so that it can be submitted to the probate court at the time of your death. So in cases where your original will cannot be found after your death, it's possible that your wishes will not be followed. So in Maryland, you can actually store your original will with the Register of Wills for the county in which you live for a $5 fee. Some people also choose to keep their will at home. You can keep it with your attorney. You can also keep it in a safe deposit box. The most important part, though, of storing your will is making sure that you and your loved ones know where the original copy is and they're able to access it in the event of your death. So if you do keep it in a safe deposit box, you should make sure that you have designated a trusted cosigner who will be able to access the box after your death. Next slide, please. So what is probate? So probate is the process of distributing property under your will if you have one, or if you do not, then to your closest living relatives based on Maryland law. And it is accomplished with the court proceeding referred to as probate. So the probate process involves the court appointing a personal representative who is then responsible for locating your property, paying any final debts and taxes, and distributing property according to the terms of your will or to your closest living relatives based on Maryland law if there was no will. This process it can be a timely process. It can take at least 9 to 12 months, and the personal representative is responsible for filing information about the probate property with the court at regular intervals. All right, next slide, please. So how can I avoid probate and have my property transfer more quickly to my loved ones after my death? So like we touched upon earlier, one way to avoid probate is to designate beneficiaries on your accounts, such as your life insurance policies, your retirement policies. You can also name a person as a payable on death beneficiary for a bank account. Also, you can complete a transfer on death, the MBA, to have your vehicle transfer to that named beneficiary at the time of your death. We also touched upon joint ownership earlier. Like I said, if there's a joint owner, the property can automatically pass to them upon your passing. We also touched, well, Karen touched upon trust. You can have a trust be created to transfer the property. And then lastly, you can create a life estate deed. Can we go to the next slide, please? So I'm going to focus on this homeownership and deeds, including life estate deeds now. So for many of us, the home is the single largest and most important asset that we have. And it's the best way to ensure that this home stays within our family, whoever we choose to keep it, is through proper estate planning. So there's a few different estate planning options for homeowners. We talked about changing the ownership of the property to a joint ownership model. You can leave the property in your will. You can create a revocable trust or irrevocable trust, or you can create a life estate deed. So can we go to the next slide, please? So I think we touched upon this, but I'm just going to go over it again. So if you change the ownership of the property, and if you add a person as a joint owner with rights to survivorship, there are some unintended consequences. So your beneficiary would become the co-owner, and upon your passing, the home would transfer to them. And this allows you to pass the home to that beneficiary without probate. But like we mentioned earlier, if your beneficiary has any creditors or any outstanding debt, that debt can attach to the property and then become a lien on your home. If you wanted to sell or refinance, you would then need your beneficiary's permission as well if there is joint ownership. Next slide, please. We mentioned leaving property in the will. So if you are the sole owner of the home, you can leave the home in your will. So if you leave your home through a will, it would need to then be distributed through probate, which can take 9 to 12 months, as we touched upon earlier. Next slide, please. So I want to talk about life estate deeds. So a life estate deed allows you to keep the home in the name of the homeowner for the term of their life, and then it passes to a named beneficiary after their passing. So a deed is a document that conveys ownership of real property, so land and buildings. And if you have a life estate deed, this deed reflects ownership of your home, but it limits that term of ownership to your lifetime. And so while you have the right to live and remain in the property during the course of your life, upon your passing, it then gives the people you named, these people are legally known as remainder men or remainder man, it gives them the right to own the property. It's a way to pass your home so that it passes to the people that you have named in your deed without probate. Both individuals and married couples can then use life estate deeds. And there are 2 types of life estate deeds that I want to cover tonight. So there's a life estate deed with powers and then a life estate deed without powers. So can we go to the next slide, please? So a life estate with powers lets you change your mind. It's like a gift that will happen in the future, that future moment when you pass away. So you've given away the house after your death, but you've kept the power to change your mind and take it back, sell it, borrow against it, give it to someone else, or do anything else the owner of a house could do. So if you do not do those things, the deed will then take effect after you die and then pass to your named beneficiary. So the main benefit is that it allows you to give this home to your beneficiary without going through the probate process. A disadvantage to this type of deed, though, is if you are eligible for Medicaid and you are admitted to a nursing home and they decide that you are not able to return home after your passing, the state can then make a claim for repayment from the home assets that you leave behind. Can we go to the next slide, please? There's also a life estate without powers. So whereas a life estate with powers was a gift that happens automatically in the future, one way to think about a life estate without powers is a gift right now to your home in the future. So this means that you don't have the power to sell or mortgage the property or devise the property without the consent of your named remainderment. because you cannot undo the life estate deed without the consent of the remainder men, you should not sign a life estate deed without powers unless you are absolutely convinced that you want to make an irrevocable gift of your home. The benefit is just as with the life estate deed with powers, it allows you to transfer this property to your beneficiary after your passing without going through probate. Another benefit is if you apply for long-term medical care, such as through a nursing home or in-home care within the next 5 years after you sign the deed. Sorry, I'm kind of lost here, sorry. So if you apply for long-term medical care, such as a nursing home or an in-home care within the next 5 years after you sign the deed, there will be a penalty period on the value of the home. But if you are able to get past that 5-year look-back period, you can then pass the property due to your heirs without the possibility of Medicaid attached a lien to the property as they could have with a life estate deed with powers. And if you are unable to get through that 5-year period, the length of the penalty period would then depend on when you apply for the long-term care and the value of the home. So that's within that 5-year period. Then can you go to the next slide, please? We touched upon this, but another way to pass property onto your named beneficiaries or named heirs, people you wish to keep the family home with, are revocable and irrevocable trust. So a revocable trust is a trust you may set up for yourself while you're living. You may transfer the property to a revocable trust in which you would be the trustee and the sole beneficiary while you're living. The trust could be changed or revoked by you. The home could be transferred to the trust beneficiaries when you die. So an advantage of this is it avoids the cost of probate, but a disadvantage is the additional cost of then setting up the trust. And then we also mentioned irrevocable trust. And this is a trust that may not be changed or revoked by you. The advantage is the preservation of the value of the home for your beneficiaries, but a disadvantage is the loss of control, and then again, the cost of setting up the trust. And I think that covers the extent of my presentation. Sorry if it feels like I sped through this. I was trying to, trying to get through it.
Oh, thank you, Tim, and Paul and Karen. And we do have a few questions from viewers. And I will, one of the questions is whether the slides will be available on the website. And I would say that we will look to put the slides along with a handbook, which is being completed with more detailed information, along with a resource directory of where you can call to find legal services organizations and other places that can direct you to attorneys who can help you with putting together these important legal documents. And so look for those in the coming days on the Maryland Attorney General.gov website. So a question I think for Karen comes, let's see, is what resources are available for elder law planning for low-income individuals?
There is an organization called the National Academy of Elder Law Attorneys, and they have a website, and they list elder law attorneys across the country, and you can look for an elder law attorney in your local area. You can also contact the Maryland State Bar Association. We have an elder law and disability rights section there, and they have you can call and they can give you some names of attorneys that practice in the area of elder law. Also, if your local county, for example, Prince George's County, we have our Estates and Trust and Elder Law section. You can call the local bar association and get the names of attorneys. There are also places like the Maryland Volunteer Lawyers Service on a statewide basis, and also here in Prince George's County, we have the Community Legal Services. But most courts in Maryland have a pro se office. They call them self-help. And you can go there and they can get you in contact with an attorney who can help if you're low income and you need assistance with your planning. And one other thing, the 60 plus legal hotline, you can call that here in the state of Maryland, and you can get assistance. You can get resources there. Oh, I almost forgot the Legal Aid Bureau. I don't know how I could forget them. They're such a strong advocate, but you can contact the Legal Aid Bureau, and they are a great resource also. So there are lots of support for folks low income in Maryland for elder law assistance.
Thanks, Karen. That was very helpful. It's good to know there's a lot of places to turn to. So Paul, this question would be for you. It's, does the 5 Wishes booklet the hospitals sometimes ask you to complete prior to surgery count as an advanced medical directive? You need to unmute.
Yes, I haven't seen the exact document being referred to, but 5 Wishes is an accepted medical directive in Maryland, so it should be fine as long as you sign it with witnesses that are eligible to sign, when you sign it.
Next question, I think, is for Tim. Is there a certain amount of assets that make probate mandatory? In other words, can you avoid a probate if you don't have assets?
So there's no amount. It's just on how it's titled. So if like we mentioned, that there's no named beneficiary, and if you're the sole owner, regardless of the value of it, it will need to be probated to then pass to your next of kin, whoever.
Right, and I think there's only one unique situation where maybe there's no more than 2 motor vehicles and a boat where there's a surviving spouse. There's some process that one can avoid probate and just have transfers take place at MVA. But Tim's right. Otherwise, there's no like minimum amount of assets that are needed.
Yeah, so yeah, I just want to. So a lot of times we see where people only have like that one. It's the family home, and they think just because it's not some multi-million-dollar mansion that it'll automatically go. And unfortunately, this is not the case. If you pass without any estate plan done, you end up in a case where people living there have no legal right to it, and they can't access tax credits, which would make it then so much more affordable to stay there and keep the property out of a tax sale foreclosure and potentially lost to the family forever.
So if anyone has any more questions, please do type them in the chat, and I'd be happy to direct them to our panel. And I guess while we're waiting to see if any more questions come in, I would just, mention that the standby guardianship form that Karen had mentioned, I had intended to make sure there was reference to a site where you can look for that form. It actually does appear on the website for the Maryland courts. So if you go to courts.state.maryland.us and you do a search for standby guardian, it will bring you to that form, and I think it makes it available in many different languages, which is nice. So another question, and let's see. So how many medical providers and financial institutions do you need to leave your documents with? So this seems to be, I guess, Paul, you might want to address the medical side of this, and Karen, you might want to address as in terms of powers of attorney.
Well, in terms of the medical side, it's definitely a good idea to have your medical advance directive with your doctor. Sometimes a hospital, if you frequently go there, might keep it for you. As I said, is a way to, through CRISP, that's the acronym CRISP, to ask your doctor to perhaps share that on this electronic database. And then the providers like hospitals that go on to CRISP can access your advance directive there. Also, the MOLST forms, to have a MOLST form completed, your doctor would need to complete it. So they would give you a copy. If you're at home, you would keep it at home, and you would keep it the places where I talked about, on the refrigerator or the bedside by your bed, in case EMS has to come at 911. So those are the main places you need to keep the medical documents.
The financial.
Just another point. I know as medical providers, but be sure the advanced medical director is given to your healthcare agent.
That was the first thing I was going to say. Make sure if you complete a financial power of attorney, you can give a copy to your agent. However, you must understand that unlike an advanced medical directive, a financial power of attorney, most organizations, financial institutions want to see the original. So your original, you should keep that in a safe place. You can give a copy to the person who's your agent, but I tell people, if you have, wherever you keep your important documents in your house, your life insurance papers, your deed to your property, there's some place that you keep all of those important papers. That's where that document should be. And whoever your agent is, they should know where those documents are kept. I have a green strong box in my house, and that's where I keep all of my important papers. If you do decide that you want to put things in a safety deposit box, you have to be careful, because if you are incapacitated, you can't go to that bank. No one is going to have the authority to go in, and you have to go to court to try and get in, even upon your death. So the best thing to do is to store it with your important papers. Make sure that the person that you named as your agent or your successor agent, that they know where those important papers are.
Thanks, Karen. And I'm going to ask you to take this one too. We talked about, life estates and how, whether they're with or without powers, it may affect Medicaid benefits, but we didn't really talk about whether or not joint ownership of assets may affect your eligibility for Medicaid benefits. Can you speak on that?
Yes. Unfortunately, Medicaid has their own regime. And so if you have joint assets, Medicaid is going to deem that those assets belong to you. I had a case once where there were two sisters, and they had everything jointly owned. And one of the sisters needed medical assistance. It's a rebuttable assumption that the Medicaid takes, but that means that you have to prove to Medicaid that the money belongs to the person who's not going into the nursing home. For example, if they're the monies that are going into the account, you should be able to show where that money is coming from. A lot of times people that are in the federal government, they have direct deposit into different accounts. If you can show whose account, where the money came from, but that can be a time-consuming process. So I'm always, when I meet with people, looking at how they've got things titled. You notice tonight we talked a lot about titling, because inappropriately titling things, or I say willy-nilly titling things, can cause you more harm and cost you more in the long run. So if you have any questions about titling, you can call and get some advice before you change titles.
All right, thanks, Karen. And we have 2 more questions, and I think we will need to wrap it up. And I will just say before we do that, if anybody on the viewing here has any questions, either now or later, you can send your questions to the email for the Attorney General Task Force. The email address for the task force is A2J TF, so that's the letter A, the number 2, JTF at oag.state.md.us, and in the subject line, just put life and health planning question. So I think our last couple questions here, Tim, maybe kind of go over one more time how you're seeing the best way for property, and this would be real property, obviously the house, what you think is the best way to avoid the property going through probate, so you avoid that 9 to 12 month delay.
Okay, so with real property, I mean, one of the better ways is with the life estate deed. If you want to avoid probate, like I said, the life estate deed allows you to name a beneficiary right then and there, and then upon your passing, it automatically goes to that person. Whether it needs to be with or without powers is more of a case by case affair, and I strongly advise you meet with an attorney to see which shoe fits in your scenario. But the life estate deed is a great tool to pass real property fairly quickly and fairly inexpensively.
Yes, so thank you for that. And then question real quick, by the way, is can you store the whole set of documents at the Register of Wills? And no, the Register of Wills only will take wills for safekeeping. So then question is, does an heir's right to real property owned by siblings automatically pass to their spouse or children? I guess I'm not quite sure about, I'm not quite sure about that question. Heir's right to property generally assumes that it's passing without a will. And so I don't think it necessarily automatically passes to spouse or children, but there could be different levels of probate administration depending on who survived who and when the timing of death occurred. But it's not necessarily automatic. It depends on, again, like Karen said, title and whether there was a will, whether there was not a will. So the better thing to do is for everybody to have a will, and then it's clear who gets what and who doesn't. So I think that's unfortunately all that we have time for tonight. I want to thank everybody here who joined us. And again, please don't hesitate to send your questions to the email for the Attorney General's Task Force, and look for more materials and information on the Attorney General's website. Thank you, Paul and Karen and Tim, for your time and your presentation this evening. And thank you to Bill Hall, who is behind the scenes making all this happen. So.
Thank you.
Thank
Good night,
you.
everyone.
Good night, everyone.
Thank you.